Yeah, good afternoon, Mr. Nedumpara. My name is Mohan Agarwal. I've been doing business since 1978 when I was 22 years old. I'm an MSME. I was never a default in banks for last 40 years. I've been paying interest. Even in Corona, I was never defaulter. Due to my huge payments blocked with the debtors, I've been landed in a huge problem. Despite bank have no soft corner for me. Suddenly my accounts have been turned NPA without asking how you have turned NPA. I have been put under a scanner. All banks are after me. They have taken recovery action against surfaces. That is very easy for them and DRT for them. So there is no solution. Since I have met you, I am finding some ray of hope as you are giving right solution for our problems. So I want to know what way civil suit and high court will serve our purpose.
Agarwalji, the question you raise, or rather the issue which you brought forward, is one which is concerning every MSME in this country. And it is something which could have been totally avoided. I say so because there is an enactment which was introduced in 2006, Parliament enacted a law in 2006, the MSMED Act. And that legislation is remedial legislation, is a welfare legislation, a benevolent legislation, or rather I put a preventive legislation. The whole purpose is to see that MSMEs do not fall sick, and where it has fallen sick, to revive it. So there's a notification was issued in 2015, dated 29/5 of 2015. It mandates, it made it obligatory for banks and financial institutions to, before any process of recovery is resorted to, constitute a committee and make an attempt whether a resolution of stress is possible. And the scope of that resolution scheme is just like the company under the company under IBC, or more exactly more like IBC, SICA, BAFR. The company, what was the purpose of BAFR? To protect industry undertakings from falling sick, and wherever it has fallen sick, to revive it. So in 2008, BAFR did not succeed, and eventually it was repealed in 2003. But in the actual notification came into force only in 2016. So the government realized that it is not possible for it to protect large industries which are intrinsically not viable, but it need to protect all small industries. That is the universal policy. It is in terms of the GATT agreement, WTO agreement, and it is in terms of the socialistic, the pattern of our society, and even forget about our socialistic, concept. Even prior to the British, even prior to the Constitution, also the British also brought legislations which are welfare in nature, the agriculture, better relief legislations, etc. So the 1951, the Industrial Regulation Act. So Section 11B of the Act says the policies of the government should be favorable. And what is the reason? See, they realized way back in 1951, the Parliament took notice of the fact that the small-scale industry is so important, is so vital because it generates maximum employment. It's the greatest source of employment. And in terms of the volume of goods and assets produced, it is the highest in terms of that. And again, from the legalitarian concept, therefore MSMEs were the prime priority for the government. But there was no legislation, and that first, except the Industrial Regulation Act, which mandated that certain industries can only be in the small and MSME sector. But the 2006 notification had two aspects. One is to make sure that the MSMEs get enough resources, enough finance. And second aspect is that MSMEs are able to recover money from their debtors. So this legislation and the notification dated 29/5/2015, this you won't believe, but the reality. Even till I took up these issues for the second time in 2021 or maybe 2020, nobody was aware of it. In the notification dated 29/5/2015, I came to know about it soon after it was brought into existence. And 2016, I filed a certain case in the High Court, and I realized the resistance from the part of the, I'm sorry to say, the part of the courts and tribunals. And the reason is, if this benefit is given, the entire recovery process will come to an end. So DRTs, DRATs will become literally have to be wound up. And the legal fraternity also, felt that it is not in their interest to take up those issues. And then I would have pursued the matter with a greater vigor, but I found there was no initiative, no drive, no support from the MSMEs themselves, because an attempt was made to form an association, even no registration was, they were not able to register even. So therefore MSMEs partly are responsible when such a favorable legislation. Now I think everybody knows it. There is a legislation, MSME Act of 2006, and the notification dated 29/5/2015. I believe now every MSME knows that there is a protective cover. No recovery proceedings. Forget about by banks and financial institutions. Recovery of rent, recovery electricity charges, statutory dues, employees' provident fund and miscellaneous provisions, EPF dues, ESI dues. No dues can even be recovered. And because the notification says that the committee, which is a judicial body, though consisting of bank officers only, and actually it is like our collegium of the Supreme Court, it is primarily consisting of bank only. And certainly the Parliament had in its mind certainly the bank's interest in mind. So their idea is to see that banks and financial institutions and the interest of the MSMEs, there is no conflict between them, and both are harmoniously construed, and both interests of both MSMEs and the banks both are served. Because if industry, MSMEs are the largest the largest number of the clients, customers, constituents of the banks and financial institutions. If they are robust, banks are benefited, and therefore it is in the interest of the banks that the MSMEs survive. And if MSMEs are allowed to all to die, and that will eventually banks will lose. Because see, if a MSME survive, they will be able to regularly earn in the form of interest and other service charges. If MSMEs die, banks will not be able to recover the entire money dues. So the government had this in mind, and the notification which the government issued has kept the process of charge of the process of resolution of stress. It was the banks were mandated to do it, and but because of the reserve banks, total neglect for MSME, the reserve banks acted so irresponsibly. The notification dated 29/5/2015 has given all the powers and has cast all responsibilities on the Reserve Bank of India to enforce this notification to extend the benefit, but RBI miserably failed. And the MSMEs, many of the MSMEs were not aware of it, and even those who were aware of it did not come forward. So now we have an opportunity, and this issue has been, I should say, wherever I have taken, in the courts have been not very enthusiastic to protect MSMEs. When I raise a MSME issue, I am given order on some other ground, because they are all probably because something which will probably being disturbed in the minds of the honorable judges is that if the protection is to be granted to MSMEs, then it will settle things. There are thousands and thousands of MSMEs who raise this issue, and it may have unthinkable consequences. But once the legislator has mandated something, then it is the duty of the courts to enforce it. It is what the will of the legislature is the will of the people. And now, so there is a resistance on the part of the courts and tribunals on one side, but there is an encouraging sign also. So because the institutional judiciary all depends on individual judges. X judge would be very passionate, very sympathetic to the MSME, and Y judge may be very hostile. and therefore that's natural. It is always like that. See, look at the case of landlord and tenant. There are certain judges are always pro tenant, and certain judges are always pro landlord. That all primarily belongs to their personal philosophy. So that is something which we have to accept it, and therefore, but this matter has to be taken to its logical, and large number of MSMEs should come forward, assert their rights, and even they must, suppose there are large number of the MSMEs, they are assembled, they come to the court, they come, then it certainly the institutional judiciary is not a machine, it's a human institution. The presence of large number of MSMEs, large number of petitions, will certainly have an impact on the psyche of the honorable courts and tribunals. So therefore, therefore I must say in all humility that I have been able to provide some succor to the MSMEs who have come forward. I am not saying that I have been able to give complete relief, but one of these matters were taken up initially sometime before Justice Sanjay Kishan called, and that was in January or February 2006. Then all matters were relegated to the High Court to decide, and later in another batch of petitions came before the Justice Khanna, who is going to be the next Chief Justice of India. And Justice Khanna, I am grateful to his lordship. He said, Nedumpara, you have raised a good issue, and these issues have to be addressed by the High Court. So the matters have been relegated again to the High Court. And since in some cases High Court has not been High Courts have not been very consistent on the same set of facts. In some parties relief was granted, in some cases relief was denied, and where the relief was denied, some technical ground was discovered where none existed actually. And in those, therefore, a couple of matters are there in the Supreme Court. In some cases, Chief Justice granted order stay. So I can say that yes, MSMEs are able to get orders, but you need to make an effort. So it all depends upon, it is not me, it is if the litigants, public MSMEs are there in the picture, they are willing to unite and assert their rights, and there to support them in all humanly possible way. If otherwise, I made a venture in 2016, and because I have no hesitation to some extent identify myself with the cause of the MSMEs. Because who are the MSMEs? They are small people who are making a livelihood. See, look at the micro industry, small investment. How many workers are there? The entrepreneur himself is everything. Maybe one assistant, one worker. So small, maybe little. So therefore, this cause is the cause of the common people. And what is at stake is the lives of thousands and thousands of people. And so too, the banks and financial institutions and individuals, there's a lot of difference. The financial institutions, there's an inanimate entity, they are not going to break. There's no mental torture or mental agony. But a small man, when he is thrown out of his home, it affects, the mental agony. Many have committed suicide. So it affects the children, the family, everyone. So therefore, the MSMEs should unite, and if you stand united, assert your rights, then the courts will be willing to listen, the government will be willing to listen, the RBI will act, banks will constitute committees, and you will get relief.